Hi, everyone. My name is George Dimitropoulos. I'm the co-chair of the International Law and Technology Interest Group of the American Society of International Law. I'm delighted to be here with you all today. And this is a warm welcome on my behalf, obviously, as well as the co-chair of our interest group, Neha Mishra, as well as Chingfu Lin, the other co-chair who couldn't be here with us today. Allow me, as we start, to extend my thanks to the American Society of International Law for hosting us, for making today's event possible, an event that we're super excited about, in fact, for two reasons. Number one, it is the first event in what we hope will be a very long series of events of our interest group, of the International Law and Technology Interest Group, namely the New Developments and New Voices series. And we invite everyone who is in this event today to reach out to us if they have pieces of scholarship, as well as other interesting ideas that they would like to present to our the members of the interest group, as well as beyond. We're always happy to hear from our friends and everyone who is interested in international law and technology and beyond. And number two, we are delighted to be introducing the winner of the last year's scholarship prize of the International Law and Technology Interest Group. Welcome, everybody. And I will pass on the floor to my colleague, Neha Mishra. Neha, the floor is yours.
Thank you. We are very delighted. Again, I'm also equally delighted to welcome all of you. And particularly, I would like to introduce Jack Nelson, who's the winner of our 2024 prize for his article, Large Language Models and the Treaty Interpretation Games, which was published in Cambridge International Law Journal. Right after I finish introducing our guests, I will actually post a link to the article in the chat as well. So the article explores how large language models handle treaty interpretation, and uses a very fascinating example, as Jack will discuss further. To just introduce Jack a little bit, he's an assistant professor of law at Thompson Rivers University. Before entering academia, he practiced law in different jurisdictions in Australia, in Hong Kong, Singapore, where he focused on international technology regulation. His academic research examines the intersection of law, science, and technology with a particular focus on space law. And in addition to his current academic role, he is also an associate academic fellow at the National University of Singapore, and previously has also served as the editor of the Annals of Air and Space Law, which is an academic journal produced by the Institute of Air and Space Law in Montreal. He has many accolades, including the prize that I mentioned about, but he was also the winner of the 2024 Brennan Essay Prize in Public International Law, which is awarded by the Australian branch of the International Law Association. His degrees in law are from University of Melbourne, the Chinese University of Hong Kong, and McGill University. I'd also like to briefly introduce our discussant. We have Deborah Hosen-Coriel today, who was, interestingly, also a member of the prize committee and is a really well-known practitioner and consultant in cybersecurity, outer space law, data protection, and cyber incident response. She was formerly the chief legal officer and VP regulation at Confidus Digital. She's also the founder and principal of her law offices, which is a practice which is focused on tailored compliance solutions for clients all over the world. And in addition to all these professional roles, she's also an adjunct professor at Rashman University and Hebrew University's law faculty, where she is on the advisory board of the Federman Cybersecurity Center. Just to add a little bit more context, she was a member of the international group of experts that drafted Tallinn Manual 2 and also contributed as a core expert to the Milamo's Space Law Manual. There are several other things I could keep talking about her, including her fantastic degrees from Harvard Kennedy School, from Hebrew Universities, Institut d'études politiques de Paris, and Wellesley College. And she's also a qualified international practitioner. So we are very delighted to have such an illustrious panel, and welcome to both of you. And we're really looking forward to the discussion. So I'll hand over the floor to Jack, who will be discussing his paper, after which Deborah will be the discussant. And then we'll open the floor for question and answers, which all our audience members can type using the chat function.
Well, thank you so much. It's an absolute pleasure to be here with you all today. I want to start by telling you all about a crash landing on the moon, a crash landing that took place in April 2019. A lunar lander, the Bereshit, impacted the moon at over 300 miles per hour. So not the soft landing that the team behind Bereshit were aiming for, much more of a hard and destructive landing. Now, this kind of event is, I don't want to say super common, but it's not uncommon to have a space mission end in such a dramatic fashion, right? Space is really hard and lunar activities are really, really hard. So the story kind of faded from news after a short period of time. There was this crash and then it kind of disappeared. Until about 4 months later, so kind of like mid to late 2019, when it was revealed that on board the Bereshit, on board this lunar lander, there wasn't just, the usual scientific instruments that you might expect. There was also tardigrades, also known as water bears. So tardigrades were part of the undeclared payload on board this lunar lander. They are tiny little animals, about 0.5 millimeter long, and the legendary survivors. On Earth, they survive in the most extreme of environments, the absolute, limit of what organisms can really handle. And so there is a high likelihood that these tardigrades are still alive up there on the moon today. Now, this issue, this disclosure of the tardigrades on the lunar lander, caused a lot of consternation amongst people in the space industry, and specifically space lawyers, because it raises a really interesting legal question. Specifically, does leaving a bunch of tardigrades on the surface of the moon constitute harmful contamination for the purposes of Article 9 of the Outer Space Treaty? Now, Article 9, in a nutshell, says that you should avoid harmful contamination of the moon, that space activity should avoid that harmful contamination. So it became an issue of debate whether these tardigrades constitute such harmful contamination. So this phrase, harmful contamination, is not defined in the treaty that we're talking about, the Outer Space Treaty. So how do we figure out what it means, right? That's, of course, a problem of treaty interpretation. And it's a specific problem that I, given that most of my research concerns space law, I've given a fair bit of thought to over the years. And so when ChatGPT was released in kind of late 2022, I got thinking about how LLMs might affect international law, how they might affect treaty interpretation, and how they might respond to this specific problem. This seemed like an interesting kind of problem to use to kind of test ChatGPT's ability to perform treaty interpretation. Now, to kind of stay in that time frame, kind of like late 2022 to early 2023, there was an absolute explosion of ChatGPT and law scholarship. There was a lot of excitement, there was a lot of concern, there was calls to arms, the usual kind of responses that you'd expect to such a major disruption. And I found this whole period fascinating. Every day there'd be new articles uploaded to SSRN talking about how ChatGPT could perform in law school, whether it could pass bar exams, whether it could, draft convincing pleadings, that kind of thing. But there was almost nothing on international law, and I couldn't find anything at all on treaty interpretation specifically. And this struck me as a kind of gap really worth exploring, because treaty interpretation is, in my opinion, central to the discipline, and it's fundamentally about language. And LLMs, large language models, are kind of language machines. So it seems like treaty interpretation is an area that'd be specifically affected by the advent of these tools. So to explore that question, though, I found it useful, and I detailed this throughout the paper, to think about treaty interpretation not just as a technical exercise, but actually as something more like a game. Now, this analogy of treaty interpretation as a game is not my idea. I draw it entirely from Andrea Bianchi's work, in which he conceptualizes treaty interpretation as a game. Now, there's an important caveat to thinking about this particular activity as a game, is to say that games are very serious business, right? We can think of how passionately people follow football, people playing chess, war games. Games are not trivial things, they're very serious. And he specifically conceptualizes, Bianchi that is, specifically conceptualizes treaty interpretation as akin to a card game. So he outlines that, like every game, you've got an object. The object is to get your interpretation accepted. And then you've got the players, the lawyers, academics, NGOs, international organizations, so on and so forth. You've got your judges as the audience, or arbitrators, other decision makers on international tribunals, as well as the broader international community, so the other people watching you play the game. You've got the cards that you're playing throughout this game, primarily the rules set out in the Vienna Convention on the Law of Treaties, but also canons of interpretation, general principles, these kind of rules that you can deploy to support your argument. And then you've got your strategy, which is which cards to play and when, and to which audiences should those cards be presented. So why does this framing of treaty interpretation as a game matter? Well, the reason I got thinking about treaty interpretation as a game and why it might be useful framing for this broader paper is that AI systems have historically been really good at playing games, specifically games with defined rules and objectives. We can think about in 1997, we had IBM's Deep Blue beat Garry Kasparov, the then world champion at chess. Watson, another IBM computer, winning Jeopardy in 2011. We had AlphaGo, developed by Google, beating the Go world champion in 2016. So there's been this, these are precursors to the AI platforms that we have today. But they've been trained by playing games, and they've been proven by playing games. And so my hypothesis going into this was that treaty interpretation, if framed as a game with clear rules and an objective, is exactly the kind of task that LLM programs might really excel at. So if treaty interpretation is a game, and AI systems tend to be good at games, the obvious next step was to see how one particular LLM, ChatGPT, which at the time I was writing this paper was kind of really the key kind of LLM that was available. The obvious next step was to see how well ChatGPT actually plays this game. So I ran a very small experiment. It's outlined in the paper. It's hardly scientific. It's just one example, but I found it quite interesting, and I think it's illustrative of how these programs might respond. So what I did is I gave ChatGPT the tardigrade problem. So, the question, do the tardigrades on the moon constitute harmful contamination thereof? But I gave it with two different prompts. The first prompt just said, act like an international lawyer. You're before the International Court of Justice. You've got to argue that tardigrades aren't harmful contamination. And then the second prompt, I framed it explicitly as a game. I set out the game, all the elements of the game I just mentioned. So essentially I said, you're a player in this game. Your cards are the BCLT articles. Your audience is ICJ judges. Your object is to persuade them. Now, the results both produced what I'd call, competent first drafts. They weren't amazing. They weren't particularly polished. But they weren't completely far off the mark of how you might approach interpreting or resolving this problem of treaty interpretation. But in my view, and it's a very subjective view, the game frame prompt was noticeably better, quantifiably better. It made the key move, particularly argumentative move, that harmful qualifies contamination. That was kind of latent in the non-game framed prompt, where it was very apparent in the game frame prompt. So it brought out this really important point that might seem quite simple to us, but I was quite impressed that the ChatGPT at that time, this kind of early to mid 2023, was able to make that move. The game frame prompt also brought up really important state practice that microorganisms have gone to space before, intentionally and accidentally. A very important piece to draw out that the non-game frame prompt didn't develop at all. And generally, it was more strategically structured. It was just structured in a slightly more persuasive way. So this all suggested to me that Bianchi's game analogy isn't just useful for academics or practitioners trying to understand or perform treaty interpretation. It actually seemed to help on this particular problem. It seemed to help ChatGPT perform the task better. So this opened up to me a bigger question. If LLMs can play this game, the game of treaty interpretation, reasonably well, what might that mean for who gets to play the game? And this got me thinking about a fantastic book that I really enjoyed reading, which was Anthea Roberts' Is International Law International? In which she argues that international law isn't truly international. It's actually dominated by Western, particularly Anglo-American perspectives and players. And so this got me thinking, well, could LLMs potentially change that? Could it make international law more international? Could it level the playing field, to stick with the game analogy? Now, there are some promising possibilities in my view, and I think some of these have come to pass in the years since I wrote this paper. We can see instant translations of complex legal texts from one language to another. We can have automated review of the voluminous preparatory works that underpin multilateral treaties. These documents are extensive, often in multiple languages. They can be massive, a bit intimidating. LLMs can be trained, I've done this myself, trained on these preparatory works, and they can kind of digest it and point out what might be particularly relevant to whatever argument you're trying to make. LLMs can also just provide a private space where you can test out arguments, you can deploy arguments, you can refine arguments before making them live or in a pleading or something like that. So it's a world of possibilities. But here's the problem, at least as I see it. This is a point that I got from my doctoral supervisor at McGill, who was very keen to emphasize when I was writing this paper that I need to address the fact that ChatGPT and LLMs are inherently backward-looking. So they're trained on historical data, and that data has its own biases. ChatGPT's training data is, particularly at that time, was a fascinating mix of Wikipedia, Reddit, English language web sources, unpublished romance novels. It was an intriguing data set. And what it completely misses out, though, is oral traditions, non-written legal cultures, scholarships in less dominant languages just wasn't considered at all, was underrepresented or absent entirely from that data set. So that's what that version of ChatGPT had been trained on. So it might be the case that LLMs let more people play the game, but if they're all playing the game the same way, shaped by the same training data, it seems that we run the risk of not really diversifying anything and just gaining a bit of efficiency in response. So even if large language models like ChatGPT could broaden participation, there seems to be a deeper issue, one that goes beyond who plays the game to looking at how the game itself evolves. And this connects to what Bianchi calls the metagame. So the metagame is about not the rules, like the VCLT rules that you might play as cards in the game, but the conventions about what actually constitutes those cards. What is a good argument to deploy? What's a card that you can play? And this comes down to the fact that the rules that you can play in the game of treaty interpretation at the moment might be seen to be, the VCLT rules, the canons of interpretation. But these rules aren't necessarily fixed forever. They can change. They can evolve in particular. And they evolve, on Bianchi's telling, through the metagame, the ongoing debate about players about what the rules should be, which moves are legitimate, and how the game itself should change. So we can think about this in terms of, for example, critical international legal scholars arguing for more evolutionary, context-sensitive interpretation. That's metagame play, trying to change the rules of the game itself. So given what I've outlined, that LLMs are backward-looking by design, they generate responses based on historical data. That data is circumspect in some respects. They're really probability machines trained on the past. So if we increasingly rely on large language models to play the treaty interpretation game, we might get efficiency, fast drafts, broader access, but we might also get ossification. That's my main concern. The game as it's being played will kind of become the game as it's always been played if everyone just starts playing it using LLMs. The metagame would stall out because the tools we're using will only reproduce what's been done in the past. So we get stagnation, benefit, or the marginal benefit of efficiency. So where does this leave us? Well, I'm not arguing that we shouldn't use LLMs at all. We will, of course, use them. I use them myself. They offer real benefits. But it's important to keep in mind they are inherently backward-looking. And international law, like all law, in my opinion, needs to be looking forward. So the challenge is to figure out how to use these tools trained on the past to build something new, to offer new arguments, to develop the metagame. So it's been a few years since I wrote this paper. Tardigrades, as far as I'm aware, are still living on the moon, on the lunar vacation. So nothing much has changed for them. But LLMs, on the other hand, have transformed a lot. You know, they've become embedded in daily life for a lot of us across various institutions, law firms, universities, so on and so forth. So they've transformed significantly, and we're still figuring out, I think, what that means for treaty interpretation, for international law, and for all of us. So I'll stop there. I'm really looking forward to the discussion that will follow. Thank you.
Thank you, Jack. I especially like the emphasis on the need to think of international law in a forward-looking manner, not just in the context of using LLMs, but even more broadly speaking, considering the state of international law that we are experiencing in different domains of international legal regulation. So thank you for sending that message out. And I have already posted the link to the paper in the chat. It's a fascinating paper. So if you haven't read it, please do read it. I'm sure you'll enjoy it as much as we all did. Deborah, the floor is all yours. I know you have to share slides, so just let us.
So yeah, thank you so much. Sharing right now. Just let me know that we're good to go. Okay, great. And everybody can hear me okay? You'll give me a sign if not. So first of all, let me start off by stating my intent to honor my 10 minutes. I may go a little beyond. And to really start out by thanking Jack for this really, really lovely paper. It's such a pleasure to read it and to come back to, and a lot of interesting points for thought. I also want to thank the organizers. And good luck with this initiative. I think it's going to be really great. I do have my few slides. I have about 8 of them. They are a bit word heavy. Please bear with me. I didn't want to miss any points, and I have gone out on a few limbs. So Jack, I'm really looking forward to your response and really pulling me back to the tree if you feel the need to do so. I want to say a word about the 2019 Brace Sheet tardigrades. I have 3 points of resounding agreement with your article and 3 points where my views diverge, and that's where I'm going to go out on a few limbs. So first of all, the tardigrades. I am just so thrilled that you use this example. I use it to teach my students as I'm sure you do, because it has so many interesting aspects of space law. And here's the Outer Space Treaty Article 9, which I know you know by heart, and you focused on the the issue of the harmful contamination. There's also the issue of due regard that comes up. So there are really interesting issues of treaty interpretation in this really, really focused and kind of beautifully designed case study. What I think is interesting, I'm going to come back to this point at the end, and so I'm intentionally bringing it up now. To the best of my knowledge, and I really followed it close since Breshit was an Israeli initiative. As far as I know, there haven't been any claims under the Liability Convention or otherwise, or any other formal state complaints so far. So I'm going to pose the question again at the end on whether LLMs and or humans need to take into account in the process of treaty interpretation how treaties, how certain articles actually play out. So we'll come back to that more at length in the end. I know it's not at the center of your article, but I'm going to treat it kind of under a different point. So starting out with the 3 points of agreement, these are the first two. This is a quote from, you should see the page. I think it's interesting. You don't see the page, but it's one of the first pages. And you write, I conclude that LLMs could help level the playing field. They could facilitate analysis of treaties, preparatory works. These are points that you've obviously recapped here. And the green ones are the ones that I agree with heartily. The analysis of the treaty's preparatory works, which you've gone into, and reducing linguistic obstacles. So really, really, really strong agreement on those points. The points marked in brown or amber are where I'm going to disagree a little bit, that they're inherently backward-looking and that their output will always reflect past conventions, norms, and biases, and I'll get to that in a second, and that the efficiency will come at a steep price of stagnation. Page 307, took it a while to come up. So the third point of agreement is that this is a quote from your article, The Disruption of the Law by LLMs. It's not near term, it's now, and you were writing 2 years ago. So just throwing up a few examples of what we have at our disposal as jurists, as attorneys, and these are just examples. Then I'll get in the end to one example that goes to international lawyers as well. So absolutely, it's not, if this is not near term, I absolutely agree with you on that point. So now I'm going to diverge a little bit. So I'm going to respectfully disagree that AI systems need to be treated as game players. And I realize that the game paradigm is a central tenet of your argument. I thought it was really intriguing. I learned a lot about game theory. I'm by no means presenting myself as an expert in game theory or in quantum theory, which is what I'm getting to in my points. As an international lawyer, I'm more convinced that the act of treaty interpretation, the thinking process that humans go through, is more based on a tree of interpretive alternatives rather than gamed probabilities. And I know this takes us beyond the scope of your article. It does land on your gaming paradigm, which again I thought was really interesting. I would go more with the Schrodinger's cat situation, in which we come to treaty interpretation, we meet humans or LLMs, given multiple interpretive possibilities for any treaty or for any legal text, in fact, only when we open the box and have in hand the final interpretation, depending on the actor, we know its substantive context. And as time goes by, I am more and more convinced that the construction of the actual legal analysis and legal reasoning in the context of international law especially seems to be retroactive. And I know that's controversial and again goes beyond the scope of what you've written, but I'd be really interested to hear how this sort of model of algorithmic behavior would play out in your analysis of LLMs. And just picking up on a point that you included in your article, that we really don't know how ChatGPT responded more effectively as a game player than as an international lawyer. And again, it's, if we have Schrodinger's cat in a box, then we've got the ChatGPT LLM in a different kind of a black box that I think really goes to the issue of how legal reasoning in human brains or in LLMs actually takes place. So that's point number one. The second point of divergence goes to the issue of bias. And here at the end, in your conclusion, I think you almost come to a recognition. If I don't want to overstate your point, but you talk about some European regulation that goes to the issue, the reconstruction of bias in, or touches on how bias is treated in LLM, in algorithms in general. You talked a lot about leveling the playing field. What I like to propose as kind of an alternative, at this more advanced point also in the evolution of LLMs, is that we know they're biased. We know that humans are biased as well. I would posit that it may be easier to correct the biases in LLM tools as they become more sophisticated and as we become more aware of how to curate their learning and their learning processes. And you go into a lot of detail, and with respect, you've done that dive into what exactly the sources are of treaty interpretation. Again, at a point in time 2 years ago. But we're now at a point in time where AI tools are evolving, proprietary AI agents, industry-specific tools, vertical AI, where we can much more accurately curate the sources that are used by these tools. We're nowhere near perfection. A lot of us have experience with AI tools. I've been professionally and personally disappointed with how well they do their job, especially in the AI agents. But it'll get better with time, and to the extent that we can intentionally curate sources, perhaps we can do a better job in correcting bias with these tools than we can in human brains. So that's point number 2. And my final point, and this is the limb I was talking about, and I'm going to put everything up here. The analysis of LLMs, it might really, if we go up a level, it might really be one example or one case study of how we juxtapose lex lata and lex ferenda. And since I'm not a Latin scholar, I had to get some help from AI with the plural of lex ferenda. I'm not even going to try to pronounce it, but the multiple universes, if you will, of treaty interpretations. And going back a little bit to I've got quantum theory on my mind, as we all do, I know. Going back to the Schroeder's cat in the box, there are many, 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 many possibilities for the interpretation of any treaty text. So it really may be in a position with respect to human jurists, international lawyers, and with respect to LLM, international lawyers or game players, really talking about how we insist with the discipline of our profession on both humans and AI tools, erasing their biases as much as possible, and also thinking ahead to different variations of lex ferenda regarding issues such as the Bereshit water bears is their pet name, correct? That right, I think. And how we restructure both the human process of legal interpretation and the AI tool process and other processes that may come into play. And just as a final point, I'm wondering whether at this point in time, given geopolitical realities and the real difficulties of not only treaty interpretation, but treaty drafting and treaty adoption, whether an important use of AI tools that should be integrated into treaty interpretation is how, in fact, treaties are implemented and whether they're implemented at all. So the Liability Convention, for example, it's a great treaty. It's never been formally invoked since its entry into force in 1972, including the Cosmos event, in which it was almost used, but the Russians and the Canadians in the end backed away from it. So that whole issue of how LLMs help us out with both customary law, which you alluded to, Jack, and also as part of our interpretation of treaties. So that's an open question, again, a bit beyond the scope of what you had written, but giving you full credit for the thoughts that you've provoked, and thank you very much for the the sort of goads that you provided for thinking. Thanks.
Well, thank you so much for that, Deborah. These are really amazing comments. The kind of comments that unfortunately make me wish I could go back and rewrite the paper, but the paper is where it is. So, but I'm grateful to now have the opportunity to both hear your comments and to respond to them as best I can at this point. So I've made notes and I'll kind of traverse through them as you outlined. I don't know if I'll be able to answer everything, but I'm gonna give it a red hot go. So the first point, I'm so glad you put up a picture of a tardigrade. They're strange looking animals. So I think that's helpful to kind of conceptualize what exactly it is we're dealing with these interlopers on the moon. You're completely right. There were no claims made by any state in relation to the tardigrades. No complaints made, as far as I'm aware, no diplomatic notes sent. Nothing. No one seemed to think too much of it. It caused, a lot of debate amongst space lawyers, but outside of that, it didn't really seem to, kind of attract the interest of states in a way that they might be wanting to complain about. For me, I was aware of that, at the time. At the time, that was definitely true. No one had complained, and I had a feeling that no one would actually complain. It kind of struck me as a fascinating story, but not one that states would really bother using that kind of political capital to, bring to the Committee on the Peaceful Uses of Outer Space or something like that. And I kind of like that aspect of it for this paper because I hoped that it wouldn't date the paper too much. The fact that there wouldn't be a complaint about this issue made, and there wouldn't actually, there wouldn't be an ICJ decision, there wouldn't be a Copuos declaration, or there wouldn't be anything about it, I thought would help preserve the paper in its kind of current state. Then, of course, the challenge is, so that's, the bearer sheet and the tardigrades, which are just an example that's used. But then, of course, we get to the fact that AI has advanced a lot, right, since then. So looking from my notes, you talked and you mentioned about, can the bias be overcome in these large language models, particularly through more sophisticated AI, through really changing that data set, getting rid of the unpublished romance novels, replacing them with, other stuff. Vertical AI, which, we're starting to see deployed within particular organizations. I would say, yes, I do think the bias can be overcome. I think that has been an excellent outcome of, if we cast our minds back to 2023, there was just a lot of concern about the bias. The bias points that I raised about the data set were not, my own individual research. My thinking there and my arguments were based on people who know much more about the mechanics of these systems than I do, and who had examined the data sets and uncovered that bias. So that incredible work that went on back then, I think, has really informed the situation we're at now, where I think we do get much less bias throughout the system. So that is, perhaps a happy change from what we might have seen in the past. Of course, it's still a work in progress, right? Because a lot of people are still using LLMs that will have bias, and you're starting to get LLMs being developed that, seem to be designed to align with particular political standpoints and stuff like this. So if people started using those for treaty interpretation, I think that would just be casting us back to the Stone Age of LLMs. You raised whether ChatGPT really responded more effectively as a player. It's a question that I debated a lot. Like, on my one example, why did ChatGPT produce that better one when prompted as a game, as though the situation with the tardigrades was a game? Why did it, bring up state practice? Why did it make a more convincing argument? Honestly, I don't know why it did. I suspect it's because applying a game with or the game analogy just gave it a more structured way of thinking. Could you get a more structured way of thinking through a really much better crafted prompt? I think so. When I do use LLMs today, I don't really use them for treaty interpretation because they're just not very good at it. So I haven't had a chance to, I'm not daily kind of prompting it and telling it to play the game of treaty interpretation and seeing what comes out. Because in my experience, particularly for the questions I'm working on, it's just not particularly great. As I outlined in the paper, I can provide a first draft, but I can also just do the first draft myself. So, and that's kind of the way I prefer to work. Others may find, other experiences. And I'd be fascinated to hear if other people have better strategies for prompting that might produce even better results. So why it responded more effectively, I couldn't really say. I think it just comes down to structure. But that kind of, to me, I find the analogy, Bianchi's analogy of treaty interpretation as a game, just quite a useful way of thinking about treaty interpretation as a way of conceptualizing what it is you're doing. So I think I'll leave it there on playing the treaty interpretation game. You raise a really interesting point about aren't human lawyers, often backward looking as well. And I think, yes, I think that absolutely is true that, I criticize ChatGPT for being backward looking, but a lot of people are also backward looking. I don't think that can be overcome, but what that emphasizes to me is the importance of these kind of more critical voices or more kind of forward-looking voices in international law and law in general, who are thinking how to move things forward. And what I'm concerned about, I suppose now, kind of 2 years later, is that some of those voices might get drowned out in a kind of tidal wave of ChatGPT developed or refined treaty interpretation. Because I think even those states, those law firms, those individuals who have these very forward-looking perspectives and who wish to ventilate them at the international level, they will also be tempted, like all of us, to use LLMs. And indeed, it could really help them, particularly when it comes to the multilingual stuff, when it comes to the preparatory works, these kinds of things, could be really helpful. So they'll be tempted to use them. They probably will use them. I'd be concerned that their individual voices might end up getting a bit homogenized by that process. You could say the same, though, admittedly, about a lot of technologies. You could say Microsoft Word homogenizes. You could say the entire field kind of leans towards that. And I would say that's probably true. But I think that remains my concern these 2 years later, that the more we come to rely on these, the more that we all start just kind of speaking the same and making the same argumentative moves and relying on the same materials. You also raised the liability convention and the fact that it's never been used or kind of used in a legal sense. And I think this is kind of ties into my thoughts about, well, what will ChatGPT be looking at? So ChatGPT now can somewhat, kind of correct itself by looking online and looking at what else has been done online. So it's not really limited to its own data set anymore. It can now search the web, do all kinds of stuff. And I guess when ChatGPT searches the web, that will come up with, well, the liability convention has never been used. Therefore, I'd be concerned that it might draw the conclusion that that's not a good instrument. That's not a good argumentative pathway. Whereas the reality is that it hasn't been used primarily, for political reasons, and because states just haven't been willing to do so at this point in time. So I guess that kind of encapsulates my concerns in a nutshell. That when ChatGPT considers this question of using the liability convention, it might look at its data. Its data might have been refined. It might be less biased than it might have been previously. But then it will also look online and be like, well, it's never been used before. And that might draw the wrong conclusion that this is a bad instrument. This won't provide the remedy that the user is looking for, or the particular interpretation that the user is looking for. So I think I'll leave it there and just say thank you again for those fantastic comments. Again, if I could go back and make some edits, I would. But alas, I'm given this opportunity to do so. So I'm very grateful for that.
Thank you. Deborah, any further comments or quick replies or
I
discussion?
can't wait for the next thank you. I can't wait for the next conversation with Jack. I'd love to see what he's working on. No, I think indebted to you, Jack, for going into so much detail about each of the points. Thank you.
Thank you. It's almost close to midnight in Singapore right now, but I must say I'm so captivated by the discussion that I don't need any tea or any coffee to keep myself awake. So it's really fascinating. And when Jack and you were having such a interesting dialogue, I remembered a discussion that I encountered, not so much international lawyers, but Supreme Court judges in a particular country, worrying about the fact that ChatGPT might prevent them from thinking creatively about how to interpret existing constitutional frameworks and applying them to new contexts, especially this particular jurisdiction has a reputation for very creative legal interpretation, and they were very, very concerned about it. So I'm glad Jack brought it up in the international legal context, but I have heard similar concerns also being raised in the domestic legal context in certain jurisdictions. So I'm really delighted
Should I just respond to that really quickly?
Yes, of course.
I was holding back on it because it's far field from Jack's analysis.
Yeah.
But to your point, here in our domestic jurisdiction, a year and a half ago, the Bar Association issued its ethics committee issued a lengthy prohibition on the use of AI tools in any, as to what you just referred to, in any materials that go to court or that go directly to clients. So it's an ethical prohibition. Now, has anyone been thrown in jail or disbarred? Probably not.
Yeah.
But it was an early, very strong statement by domestic law, probably honored in the breach, but at least that was the thinking. It's probably already completely irrelevant in terms of an ethical prohibition.
Yes. It's very interesting. So I request the audience members to please type in your questions in the Q&A box. But we already have one question. So Jack, Deborah, I'll read out the question. Either of you, please feel free to answer the question. So the first question is from Garima Singh. Thank you, Garima. The question says, can we say that LLM manipulates cognitive liberty or freedom of thought? It's a big question. Any reactions?
I would say it's more that we allow, or we will always be tempted to LLMs to change. I don't know if I'd use the word manipulate, but change our thinking patterns and how we think about particular problems. Because as humans, unfortunately, we're often looking for kind of shortcuts, right? And particularly, in general, lawyers are often very busy, often somewhat overworked. And so anything that can kind of, help move things across one's desk is often, somewhat welcome. So I think that that's the kind of risk, not that we're being manipulated by them per se, but that our temptation to use them and our temptation to be more efficient, that we end up having our own kind of freedom of thought somewhat circumscribed, I think is how I'd respond to that. But I'm super interested to hear Deborah's take as well, particularly as a practicing lawyer.
I think it's a hard one. I agree overall with Jack. I'm afraid I do have a bit of a Luddite take on it, so that I would agree that not only LLMs manipulate cognitive liberty or freedom of thought, but pretty much, I'm going to say it, anything we do online because of the influences. So again, probably not a popular view, but I think that LLMs do in fact take us to sort of that one grade beyond, or that one level beyond. But I think everything that we do digitally is somehow impinging on freedom of thought. I hope I'm wrong.
Thank you, Deborah. Thank you, Jack. We have another question. So it's from anonymous attendee. So I don't know the name of the audience member, but thank you so much for your question. The question asks, are there situations where it makes sense, for example, in bilateral and plurilateral agreements, to ensure that the LLM interpretation is actually or should actually be biased so as to reflect the understanding of the parties that negotiated and entered into the agreement?
What a fantastic question. I would say, in a way, yes, there are some situations where an LLM that's trained on a very limited data set, you could describe that as biased, but it could also just simply reflect the task that it's going to be given. So in a bilateral treaty, for example, you could upload the entire preparatory works for that treaty. You could upload the entire political context. You could upload the history of the relations between these two countries, the object and purpose, as it were, of the treaty as a whole. You could upload all of this, and you could say, this is your world, LM. This is what you're going to apply to resolve what a particular question means. I think it could be potentially very effective for coming up with those arguments that are heavily, based on preparatory works, historical circumstances, so on and so forth. So it could feed into a broader argument. But when it's biased in such a way, I think it would only ever be a part of the argument, right? It would be completely divorced from the rest of international law, for example, general, other aspects, other treaties that might be relevant, similar treaties that other countries might have signed, all kinds of things. So I think it would be a useful tool potentially as an adjunct to engaging in your own treaty interpretation that would be much broader. But it could, arguably provide just, that little interesting points, preparatory works, historical context, so on and so forth. So I think it could be a useful exercise, but it couldn't be, the whole thing. It would really require just being fed into a broader analysis that I really think at this point in time a human would be better placed to do.
Add, if I may, that as I read the question, I was thinking, this really reminds me of something like, and Jack has just described this. In my head, that would be something like the International Committee of the Red Cross, the ICRC, sort of an authoritative interpretation, or maybe authoritative is a strong word, but very well attributed interpretation, which is based on very, very specific curation of sources, as Jack has described. But I think it goes to the point that we discussed earlier and that Jack raises in his article, that interpretation that the anonymous asker has posed will never take us to lex ferenda. It will remain in the lex lata stage. And if that's one of Jack's critiques, then that's something that's the bias that we would take, or one of the biases we would need to take into account. This is the lex lata picture. Take it from here.
I don't see any other questions in the Q&A box for now. We have a few minutes left, so I'm wondering if there are any other thoughts, Deborah and Jack, you'd like to share with our audience members, because I know I was very strict about the time limits, and perhaps there were things that you would like to mention which you didn't get a chance to mention earlier.
I'd love to ask Jack how he's using LLMs right now beyond, if you're willing to share, Jack, as legal tools beyond, the great job that these tools do with editing, with shortening our abstracts and helping us get to sources. So I'd love to hear from you what you're relying on.
I'm very happy to answer. I was literally going to ask you the same question because I'm always interested in hearing about how other people are making use of, kind of new technologies, new tools. So, in my classes, for example, that I teach at Thompson Rivers University. So, for example, I'll be teaching air and space law on Tuesday. It'll be the first class of the winter semester. And I say to the students at the beginning, other than the exam, and that's simply the final exam, and that's simply because the final exam is closed book, they can use any AI tool they want in any aspect of the course. They can use it in class. They can use it to help them with their readings. I completely give them carte blanche to do whatever it is they want. And that's just how I've approached it. My colleagues approach it very differently. And that also kind of reflects how I use it. I dive in and out of using LLMs all the time, and I find them, incredibly useful for some things. Perhaps you're writing a paper and you've got two good paragraphs, but you can't think of a transition sentence to get between them. Occasionally, I'd say about 70% of the time, I put that task to an LLM. It comes up with a pretty good transition sentence. I always end up having to edit it, but that might be my own preferences. I always end up having to edit everything a million times. But just coming up with little things like that, that's very simple. Searching in a large PDF, say you've downloaded an ebook, for example, and you read the ebook and you know that at some point the author, she talks about, XYZ issue. You can't remember what page. Perhaps you wrote a footnote when you were, typing up a paper from it or something, and you wrote, "Oh yeah, it's the Smith book," and then you've completely forgotten anything else. Putting that task, uploading that PDF to LLM and saying, "Oh, at what page does the author talk about this issue?" Super useful. That saved me, I don't want to say hours, but a fair bit of time, right? So these are the kind of ways I'm using it. When it comes to kind of using it to actually perform the legal analysis, I find it, just not very good. I find that the time that I spent, prompting it, trying to get it to a good answer would be better spent just doing it myself. So that has been my experience. Other people may well have different experiences. I might not be prompting it correctly. There might be better LLM tools. I use a whole range of them, many of them of which you included on that slide. So there's a lot that I use, but has it been game changing? I would say overall, it's probably given me efficiency gains of about, I don't know, 10%. So that's useful, right? Like that, it's a busy day, and having 10% of your time back is good. But has it been revolutionary for me personally? Perhaps no. Perhaps no. It's just kind of helped me do what I was already doing a bit quicker. So that's my take, but I'm super interested to hear how you're using it, how you're using these tools. If you are.
That's really helpful. Do we still have a minute?
Oh, sorry, did I speak too long?
Yes, indeed. We have 3 minutes left, so, 2 minutes left. So please go ahead.
So I'll try to. So this is actually really helpful. I'm hoping that it's helpful to the listeners as well. So I was thinking, I thought of two examples. One is a not so good one, and one is similar to yours, Jack, a helpful one. I dove in pretty early on, probably too early on, to an AI agent. To really curate my sources. It works, I don't know if everybody knows this, but it works on sources that are predefined. It's a proprietary situation, so it's can be asked to bring in sources from the outside, but it's really going to work on your home database. So let's say, for example, in the context of cybersecurity law and space law, so it would be, these are the 1,000 articles of the past 10 years that have been collected in my own database. I just made that up. I think it's probably more actually, but a very, very small percentage has actually been gone through my brain cells. So take this database that I've accumulated, and any queries that I forward, please use this database to do it. And it was a really big disappointment, not so much in terms of the content. I have exactly the same comments you do, Jack, as to, to what degree can we as professionals rely on it. So not so much in the content, but the user experience was way behind the curve, and it still is. So instead of getting a daily dashboard of, here are the updated responses to your queries, which is what we should all, which I'm expecting today to be served every morning with my breakfast by a robot who comes from the kitchen and says, "Here's what I have for you today." Maybe a little bit behind that curve, but I think perhaps my observation would be that I know that a lot of work is being done in the back office. Everything I've seen is way behind the curve in terms of user experience. So that was a big disappointment. So I left the AI agent use and back to using my own brain. The really good, I know I'm beyond a minute, but I'll do this really quickly. The really good example that I have from today, and I'm outing myself to my students. We did in the space law class today, we did an in-class simulation, and it's an unseen description of events that they see for the first time and need to analyze in groups. And the exercise done, again, maybe this is too much detail, but it's a happy hint for any of those who are watching or teachers. So I inputted all of the class presentations of the entire semester, so 300 slides, and asked the LLM to construct a scenario that the students could, with instructions, but that the students could analyze, and it worked beautifully. Obviously, a first draft or maybe half of a first draft, but at least the scenario was placed. It was really good at that. So
that's a great
example.
great use case. That's a super useful. I'm going to be using that.
Thank you both. I think a lot of food for thought, and I think it has been an absolutely fascinating discussion. So I'd like to first thank Jack and Deborah for joining us and sharing your expertise with us. I also thank James, Taylor, Britta, and others at ASIL for helping us organize this event, and also my co-chairs, George and Chingfu, for being there through this journey. And as we mentioned in the beginning, it's the first in our edition in this new series. So we hope we'll continue this tradition, and hope some of you who are attending or who might hear the recording would also reach out to us if you would like to share and be a part of the series in the coming months and years. Thank you very much, Jack. Thank you very much, Deborah. Have a good day ahead.
Thank you all.
Everybody. Thank you.